Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
All right. How is everybody? Wanted to talk to you today about Karen Reed and whether she's winning or losing. Is when she thinks that Team Reed is winning, is she really losing? And this came to mind because, of course, Dr. Marie Russell, who most of us, not just me, thought was the worst expert witness in the history of the world, is now going to be in the retrial. It was a decision by Judge Cannoni. And where I disagree with her is I disagree that she meets the qualifications of Daubert. We can go over that again. But again, I'm not a lawyer. I don't pretend to be one. Just my layperson's understanding is that she has to have some methodology behind her decisions. So if you haven't heard, Marie Russell is coming in, which is what some of you guys wished for. Some of you were saying, let her come in. And in a way, I agree with you, because she'll make Team Karen Reed look so bad. So let us look at the decision before we go any further. And it's like the worst copy known to man. So before the court's motion to exclude the proposed expert testimony of Dr. Marie Russell, Dr. Russell intends to testify as to whether the abrasions on John O'Keefe's right arm were caused by a dog. The Commonwealth contends that the defendant, has failed to show that her testimony meets the requirements set forth by Daubert v. Merrill Dow Pharmaceuticals. Although a close question, the court will deny the Commonwealth's motion. So the most interesting part is the last paragraph. In so ruling, the court recognizes that on cross-examination, the Commonwealth demonstrated, among other things, that Dr. Russell's expertise primarily concerns the treatment, not the identification of dog bites, that her evaluation of the abrasions failed to consider all available information, that she has not compared the abrasions with the dentition of the German Shepherd in question, i.e. Chloe, that's me speaking, and that her opinion is inconsistent with findings that there was no canine DNA in the area of the victim's clothing near the abrasions. However, the court concludes that these issues go to the weight of Dr. Russell's testimony, not its admissibility. I disagree. And can be addressed during cross-examination at trial. See Hines. So I'm not familiar with the Hines 48 mass in evaluating admissibility. A judge does not, and then it says ... determine whether to credit the expert's ultimate opinions. But they have to have a standard as to how they determine that they're dog bites. You can't just say, I've seen a dozen dog bites. That's how I know it looks like, because a lot of things look like other things that aren't. An onion and an apple look a lot alike, but aren't. But okay, so let's just review just the Wikipedia, not my favorite source of anything, but just for brevity's sake. On Daubert standards, judge is the gatekeeper. The task of gatekeeping or assuming the scientific expert testimony truly proceeds from scientific knowledge rests on the trial judge. Relevance and reliability. This requires the trial judge to ensure that the expert testimony is relevant to the task at hand and that it rests on a reliable foundation. A conclusion will qualify as scientific knowledge if the proponent can demonstrate that it is a product of scientific methodology derived from the scientific method. The court defines scientific methodology as the process of formulating hypotheses and then conducting experiments to prove or falsify the hypothesis, and provide a set of illustrative factors in determining whether these criteria are met. Whether the theory or techniques employed by the expert is generally accepted in the scientific community. No, it's not. You can't just say, I've seen, because it looks like, it resembles. Whether it has been subjected to peer review publication. Well, she's done peer-reviewed articles on the bite and hold method of police dogs, hardly very different. Whether it can be and has been tested, whether it has a known error rate, and whether the research was conducted independent of the particular litigation or dependent on the intention to provide the proposed testimony. So my thinking, although my friend disagrees with me, is that Richard Green's coming in then. To me, my conclusion was she already let Marie Russell in. She's worried about whether it could be appealed on grounds of, I would assume, insufficient defense. And she's already let her in once. So same thing's got to go for Richard Green, right? I would think, even though it's very different when the whole, so Richard Green is the digital forensics expert who testified that he was sure that Jen McCabe Googled Haslong to die in the cold at 2:27 a.m. instead of 6:23 and 6:24 a.m. as the Commonwealth contends, and as the whole program, Cellbrite program, had to be rewritten to avoid errors in reading the data like Richard Green did in the Karen Reed trial. So I assume that it's all coming in. ARC is coming in. All the experts are coming in after that ruling, because never have I seen a worse witness than Dr. Marie Russell. But we had some typical, what I'd call all innocents, fraudsters, and grifters weighing in on Marie Russell's testimony. I've been meaning to get to it. Let me just pull up the video file. Here we go.
And when you were considering that information, did you know?
So starting with Julie Grant from Court TV and her guest.
From the criminalistics reports that shards of that broken taillight were littered in his sweater.
I did not know that.
When's the first time you learned of that?
Right now.
Now for what's tipping the scales in the case against defendant Karen Reed. Specially appointed prosecutor Hank Brennan came out swinging during his cross-examination of Dr. Marie Russell. She is the witness the defense team wants to call to give the opinion that what happened to John O'Keefe's arm was a dog bite. Now, we know that Chloe, the family dog at the residence at 34 Fairview Road at the time, had an incident where she did bite someone.
That's Chloe's bite on the right. Kitties, 1993. Does the judge really have to bend over backwards to give the defense the benefit of the doubt? Doesn't it seem like that? This is why I've never been in love with Judge Cannoni. She seems to... She's a former defense lawyer herself, and she does seem to bend over backwards for the defense. Now, if you talk to the Free Karen Reed people, they think she's so biased, she's going to bar it's a big conspiracy, and she's going to bar all the witnesses out of court. Maybe she's reacting to that. Who knows? But I didn't feel that Marie Russell met the standards of a good witness, a sound witness, a witness that could advise the jurors in a sound manner, in a reliable manner. Seems like Cannoni could have easily rejected her, doesn't it? I thought so, but she let her in last time. That's what I really think it hinges on. Dean Walker, nice to see you. Thanks so much for the super chat.
And previously, so Hank Brennan was smart. He introduced in this hearing actual evidence of one of Chloe's bites. You can see it there on the right, and was looking for comparison to the injuries to John O'Keefe. Take a listen.
This is not consistent with the dog biting and then pulling the skin.
This is consistent with an avulsion wound caused by a dog.
Okay. Very different wound than we looked at on Mr. O'Keefe's arm.
On
Mr. O'Keefe's arm, very different, right?
Correct.
Your opinion that this is a dog attack. Mm-hmm. Have you ever had peer review of this opinion with this photograph?
No.
We have a special guest we're going to bring in now. He is a canine expert.
It's just I had to laugh a little bit. Your opinion that this is a dog attack? Mm-hmm. Did you hear her do that? Mm-hmm. The reason you don't do that, I mean, that'll show right there that she's not an expert witness. The reason you don't do that is because there's a court reporter there and you don't want the record to read, mm-hmm. How are people going to interpret that? Mm-hmm. And I guess they are. Artworks says allowing Dr. Russell's an expert will come back to bite them. Very funny. So listen to Julie Grant. So for about the first 5 minutes, you think, oh, maybe she's got a really solid guest on. And then he goes into bizarro territory. Check this out.
Been certified in both state and federal court to give opinions on dog bites and other canine matters. He's a retired lieutenant as well. Mike Gould, in a favorite on the program as a law enforcement analyst. Thank you for doing this comparison for us. We want your expert opinion. So, Lieutenant, when you look at these two pictures side by side, tell us what you see, please.
Yeah.
So, Julie, yeah, this is a little frustrating to me. This is like trying to explain to my granddaughter that the earth is round. The easiest thing I do is just show her a photograph so she can understand it, a photograph from space, and you can see the earth is round. These things are two completely different injuries. One is clearly, that's all you have to see, and that is a dog bite. The witness is calling it a avulsion. Obviously, that's the diagnosis of the injury. But what it's created by is one of the dog's canine teeth. You can see it clearly. That's a left hand, it looks like to me, maybe. The photograph of John O'Keefe has no canine punctures from a dog. They're primarily scratches from claw marks from, in my opinion, a scavenger animal that has claws to climb, and they're razor sharp. Dogs' claws are not razor sharp. Their dogs' paws, nails are primarily for digging holes. We have nails, and so we have a lot in common. We have a certain amount of teeth. Humans have 32 teeth. Dogs have 42 teeth. We have a lot of similarities. The wound on the right is a very typical bite created by the dog's canine teeth. Canine teeth are used for tearing and ripping. Incisors are used for chewing, and molars are used for crushing. So a lot of this, in my opinion, just went, way crazy. We're talking about paradoxal undressing and so forth. This is so clear to me that it's not a dog bite. You may not have to accept the fact that I believe strongly it was a scavenger animal, but I can tell you with certainty these marks were not created by a dog, particularly a German Shepherd or a dog of that magnitude. This was, again,
Right? So you think he's making sense, but then he goes into scavenger animal. Scavenger animal. Scavenger animal. Do we need... I mean, all these experts, and there's so many bogus true crime experts. It's amazing to me. And true crime grifters out there. Thanks, Magic Lady, for being a member for 4 months. Love you, Roberta, she says. I love you too. All right, here we go.
I can visualize it very clearly. A scavenger coming out at 2 o'clock in the morning, detecting a warmer part of the snow than others, and started digging at it and was scared away by somebody in the house, and that's the end of it. This couldn't even happen to a live, conscious person, those wounds, because it would require the person to lay down with his arm out and allow an animal to scratch them. So it's ridiculous.
Why is he stuck on animal? Do I need to bring up Boundless Millennials' fantastic video one more time, where he shows the metal casings? Like, apparently I do. The metal casings of Karen Reed's taillight and how they would create these kind of wounds. I guess I'm going to have to bring it up again. But this is ridiculous. He thinks it's a possum. A possum. All right, back to this.
Ridiculous on almost every level. And, frankly, the DNA, whether there was DNA on this wound or not, it would not, canine DNA, it wouldn't change my opinion one bit. You can, our other experts can argue how DNA got there, but it doesn't, this is not just simply not a dog bite or a dog scratch.
And we certainly value your opinion immensely, Lieutenant. And as you noted, the evidence shows no canine DNA whatsoever was found on Officer John O'Keefe. So there is that. There's also no evidence that was presented at trial or that even exists to show that he was in the house. There's zero evidence of that as well. During this hearing, and you were watching it with us live, Lieutenant, you were on this program with me for part of it, and then later in the day, after I had left the desk, something really, really illuminating happened in my view. I thought it was just brilliant advocacy that Hank Brennan held that witness's feet to the fire and said, okay, you say dog bite. Well, I'm going to take you through every single mark on this arm. I'm going to ask you what I know you saw it, Lieutenant.
Anybody remember that? It's not unusual that the canine teeth are upside down. They're going to go through it. They're going to go through it. There's so many points It was such a long hearing. I had to edit it down, but this is another great. I did talk about this, but we didn't see it together. This is another great moment here. It's like, it's ridiculous to think that they're dog bites. It's clearly possum bites. It's clearly possum predation. They just sort of scratched a little bit and ran away for no reason. I mean, come on.
We've got a clip of that. This clip in particular was kind of like the moment of the cross, or one of the big moments, if you will. There were a few bombshells, but let's take a look at this together.
You see that this here, 2 teeth, if the dog's canines started here and worked their way down this way, they don't line up. They're not even. It's backwards.
It would be an odd configuration.
Well, odd. It would be like Ripley's Believe It or Not. The dog would have to have their teeth the opposite way.
No, I could see how that could happen.
Really?
Yeah.
Okay.
Oh, Lieutenant, what did you think of that moment?
Right. Well, I love those, the courtroom drama, the smoking gun. Apparently.
Yeah, who doesn't love when a expert witness is made to look ridiculous? I hope you're right, Brooke. Brooke says Hank Brennan will win this case. I'm feeling very down. I'm not convinced that Turtle Boy is going to get convicted of any charges in the witness harassment case, and I'm not certain that Karen Reed's going to be convicted. Not in Massachusetts. I don't know. Maybe in another state. I think we may have another hung jury again. It depends on how they pick the jury. If it's a fair jury, she should be convicted. Heisenberg says the way this new prosecutor is going to be in trial, I'm very glad she's allowed. That's the sentiment of a lot of people, Heisenberg. Hank is going to have a field day against her Karen Reed's witnesses. True. He's a very good cross-examiner. I wish he listened a little bit more. I hope in trial he'll listen a little bit more to the answers and really respond to them and not feel so pressured to get to his next question. But that's the way that lawyers are trained, that the question is everything and the answer is not important. So you control with your questions.
But if I was testifying, I would highlight the fact that, in my opinion, those weren't even teeth marks. Those were scratches created by claws, not teeth. And I would show you pictures.
I would show you pictures of the taillight. That's what I would do. Where do they get these guys? And there's dozens of them in true crime. Just totally flying by the seat of their pants. Like, I've seen some opossum scratches, so looks like. Do you ever know? So I'll just assume. Do you ever hear the phrase, assuming makes an ass out of you and me? There you go. Nobody starts with, I told my little girl that the earth is round. Well, so is an orange. So is a basketball. If you paint a basketball with a world map to look like a globe, and how, is that the world in suspension?
A possum scratch. I keep going back to this possum thing. I'm obsessed with it, I guess. But I would go back to showing you how a possum climbs a tree.
Yeah, about how a possum climbs a tree. And they were just climbing John's body because it couldn't possibly happen to him when he was vertical. Here we go. All right. Well, here we go. So I just want to show you Boundless Millennials. Really very quickly. He called this the grifters. Free Karen Reed. So just to go back a little bit.
Has 27, 30.
My apologies. Let me cue it up again and we'll get back to it. But I had it perfectly queued up. I just hold on one second. I know I can do this. Let me just share my screen. It's just hard with these shorts. So there's Melanie Little talking about, there's that. There we go. Look at that, how that lines up. Did everybody see that? I know that's hard. Let me go back and one more time. See that? The taillight casing, how that makes that exact same scratch? So for those listening on podcast, it's just a bit of the taillight casing, and it makes almost an identical scratch to what was on John O'Keefe's arm. But this guy is going, I'm sure it's a possum. I'm sure. I know I'm a little obsessed with the possum theory than I may have just thought of 6 minutes ago. But I tell the jury it's a possum. I'd get in possum experts.
And those exact striations with the exact width of each one of those marks are identical to that of a scavenger, not a dog. And they're not bite marks. The bite marks are in the center of that photograph. So in my opinion, the claw marks on each side are what a scavenger animal would use to hold down and nibble away at the flesh, which you can kind of see little bits of that in the middle of the in the picture there. So, I could almost determine.
And I just feel like the true crime world, the less discerning, just love this stuff. It doesn't have to be true. It just has to be a new theory. Whatever the new theory is, they'll just go for it. If someone in authority is saying, with any little bit of authority,
which teeth, whether it was one of the 4 canine teeth, whether it was the incisors, or in this case, claws were used on those outer striations, and the rest was. Yeah. And this only took a second or two, and the animal was obviously scared away by noise inside the house.
And this is interesting, Lieutenant, we're almost out of time, but quickly, something that came up, teeth versus claws. Are you able to tell when you look at a bite that is, in fact, from a dog, are you able to tell?
She's like, let's get off this possum stuff. She's like, yeah, great stuff with the possum stuff, but let's get off of it. Is there a difference between claws and bite marks? Because Marie Russell, her testimony was going all over the place. Could be claws, could be bites. So it's a good question to ask, but I don't know if this is the person to ask.
What marks come from teeth versus which come from claws?
Absolutely. So wow. Claws are scratching marks. You could try it with your family pet. Take your little French bulldog and try to reproduce. It's not going to happen. You couldn't do it. So you easily identify each tooth and scratches and claw marks.
Lieutenant, as this doctor was saying on the stand yesterday that she couldn't, and that was a fact that Hank Brennan obviously talked to someone like you. He talked to someone who clearly got him all. I mean, he was prepared. He came in ready to play. I mean, he represented Whitey Bollinger.
Yeah, they all just really admire Hank Brennan. He has developed quite a name for himself as a super lawyer. Sure, he demands the big bucks. He's a defense lawyer. But he destroyed her. Maybe he talked to someone like Jim Crosby. Maybe that's what Hank Brennan did. Who's going to be the lawyer for the Commonwealth? That could be. And he's incredibly knowledgeable. We've gone over he's getting I think he has a PhD in this stuff. So I think Marie Russell, and he's testified in multiple trials. You can look him up on YouTube. He's gotten 2 degrees in veterinary forensics, Jim Crosby, and he's going to testify for the Commonwealth. So I think they're going to be blown away. We can check him out. I mean, I've already showed you his, very long CV, dozens of, seems like at least 10, to my memory, trials that he testified in, but that's just my memory.
This guy knows his stuff. He's surely able to prosecute Karen Reid, and he's doing it with such precision and brilliance. Have to leave it there. Lieutenant Gold, thank you so much for your opinion and your insight. Likewise, we'll see you soon. And my friends, that's all for this episode.
Thanks so much for your crazy opinion about possums. Thanks so much. We've totally disregarded it, but thank you. So now we have Vinny up next. After this, Vinnie Politan is enraged by Hank Brennan's cross-examination of Dr. Marie Russell. Vinnie Politan, who had on everyone wearing pink when it was the Free Karen Reid color, I think it still is, on his show, but pre-trial for Free Karen Reid on his show. Now, this is his YouTube channel, and he called the episode Prosecutorial Madness. So I just want to play the beginning of this for you guys to get a taste.
Prosecutorial madness, what I'm seeing in the Karen Reid case. They are not acting like normal prosecutors. And are they breaking any rules? Not necessarily. Not necessarily. But you really have...
Wait, so that's what you call... So he doesn't want to call it he's a lawyer, so he doesn't want to call it prosecutorial misconduct, because that would be alleging something criminal was done. So he just wants to toe the line. He's like, was something criminal done? No. So if it didn't break the law, it can be done in court. Does it break the rules of the profession? Because that would be misconduct too, Vinny. No. He's just never seen it before. Done before. So what does that mean? Why is it mad? How about prosecutorial iconoclast? Same kind of thing. Let's hear what his problem is with Hank Brennan. He's like, is it illegal? No, but it's madness. I just don't like it because I want to see Karen Reid, the accused cop killer, get off. That's just me, Vinnie Politan, because that's also strangely where the money and the views are in the Free Karen Reid movement. So I'm going to side with them for some vague reason and just hate on Hank Brennan and his brilliant cross-examination of Marie Russell.
To pull back from this and take a look at the big picture to fully understand how different all this is, and then try to understand why. That's what I'm interested in, is why are they acting the way they are acting? And there might be an answer.
Maybe because a true crime fan who was an ER doctor, who worked in the coroner, was also a cop, is inserting herself into a high-profile trial after reading about it in the paper. Maybe, just maybe. Does anyone remember this? When Marie Russell got herself written about in the paper? She does admit her preferred recreational reading is true crime. She's the equivalent of a turtle rider, expert witness. So maybe that's what the prosecution objects to, Vinny.
Answer to it. And it might be a pretty simple answer to it. But what we're seeing right now in the Karen Reid case, I've only really seen in one other place. But that was more the actions of the judge than the prosecutor, although it kind of goes hand in hand, in the Delphi case. And what you're seeing is prosecutors not acting the way they normally do.
Because Abby and Libby's killer was another killer he was rooting for. So he had issues in that case too.
In trying a case. Now, I've been covering cases across the nation, the highest profile cases, for decades now at Court TV. That's all we do, is cover high profile cases. So These are cases many times with strong defense teams, with defendants who may have money, they may have fame, they may have access to resources that the day-to-day defendant in our system doesn't have. And that's certainly the case here. But it doesn't change everyone's role. And I've spoken at length through the years about the role of the defense attorney and the role of the prosecutor and how they're different. And when I usually talk about it, I'm usually attacking the defense, sort of in a passive aggressive way, but attacking the defense in what their role is in the courtroom. But what I'm seeing here is a little different, and I'm going to explain it all. It will make sense once I put all my thoughts. How is that a system of justice? That doesn't work. So that's why it's different. So
wait, go back.
Whereas that is the ethical obligation of the prosecution. Okay, so now you lay that out, and it makes sense. You believe that once those facts and evidence is put in front of the jury, that it clearly proves that the defendant did it, and you've proven it beyond a reasonable doubt. Okay, that's your job. And the truth. It's all about the truth, because that's how you equal justice. I mean, someone gets indicted because they did it, right? That's
right, but unqualified experts, that doesn't mean you can have unqualified experts mislead a jury, Vinny.
It's your job as a prosecutor. At least you believe they did it. Now, a defense attorney, on the other hand, completely different.
No one is saying Karen Reed can't find a qualified dog bite expert to come in and say those are dog bites. But guess what? I don't think it's so easy to find a dog bite expert who's going to say that. Look at even Mr. Possum obsessed can't say it's a dog bite. I know it's challenging because they aren't dog bites, but that's the challenge in defending, in my opinion, a guilty client. All right, I've had enough of Vinny. That just gives you a little taste of what's going on with that. Also, does anybody remember, we were talking, actually, let's get into your comments really quickly. That might be a good segue in.
We got your comments. You had something to say. You were insightful. Oh, so clever. So Roberta's going to read your comments. Hey, Roberta, read those comments.
So last we were talking about Aiden Turtleboy Carney, the blogger, who was really like Karen Reed's flying monkey in this, who Karen Reed really conceived and spearheaded the witness harassment campaign, in my view, with Aiden Carney doing the heavy lifting. At Mo says Aiden is addicted, meaning Aiden Carney, to going to court. There's no medical diagnosis for this type of addiction yet, but it's real. He's been at it for years. He enjoys it, and if I was Lindsay, I would tell that to the judge. The endorphins from the overall process of court, and of course the judge's final decision, be it win or loss, could have taken over his life. He enjoys court too much, and if I'm correct, which I believe I am, then he's going to be in court for the rest of his life, or of course, probably prison. I don't know. He's gotten a pretty good education in innocence fraud. He's given himself a serious graduate degree, at least in innocence fraud. He may get away with it. I'm not convinced he's going to go down with these charges. Doesn't mean I'm rooting for him. It's just the way I see things going now. Crippled Alien says, how disgusting to hear this, the hypocrisy. So Aidan Carney's accuser was trying to extend her restraining order. How disgusting to hear this, the hypocrisy, the lies. Is there corruption allowing this guy to get away with whatever he likes? Makes me sick. I don't think it's corruption. I just think it's an uneducated judge on coercive control and DV relationships. Speaking of, Susan Q says domestic violence and Karen Reed, she checks all the boxes. He was done with her. I agree. That's my theory on the case. On Karen Reed, Karen Reed had been coercively controlling John O'Keefe. He had ended the relationship and she did what she'd been fantasizing about doing. She ran him over with her car in reverse, 24 miles an hour in reverse, her foot 75% down on the gas pedal, never once touching the brake, with her infotainment system blaring, beeping, and flashing at her, telling her she was going to hit something. She could not have missed that infotainment system, which is why I say that shows intent. Her intention was to hit him. So does anybody remember Mary Bagwell? From Aidan Carney's restraining order hearing? If you don't, I'll pull up Innocence Fraud Watch. Has been writing blogs and putting up stuff on her Rumble account on that.
My son, Jacob, saved her kids, both of her kids, twice from drowning in Carrie Lama's pool. Twice. And I watched her kids because she was too busy gossiping about Aidan.
All I talked about was how my son saved your children 3 times from drowning.
So it's changed from 2 times to 3 times. And you'll see as this clip goes on that Mary Bagwell says that she saved Aidan Carney's accuser from, or victim from 3 times. She changes it to 3 times. And the first time was that she wasn't paying attention, what she was gossiping about Aidan. And then the second story is that she was too drunk, which wasn't. And witnesses who were there say this never happened. Other witnesses.
Because you were too drunk. And too
asking you if you're aware that it's published.
So there's that. But here she's talking about why she turned from being Karen Reed is guilty to supporting Karen Reed. Take a listen.
No, at the time, I didn't think she was innocent.
So at this time, you thought she hit him and peeled off and left him for dead.
Well, because Kate and Lindsay and all of them were telling me that they disclosed. Now we know it's not true, but at the time, everyone believed it was true that Karen disclosed to David Yannetti that she hit him. But everyone believed that when it first came out. They lied to us. I didn't know.
So wait a minute. So let me wind a bit. So there was a text message allegedly back in the day, right? That
Tammie says, I read all the Innocence Fraud Watch blog on this subject and it blew me away. Great work she does. Doesn't she do great work, Tammie? And her timeline is just invaluable to me and other people. I assume other people who follow this case.
That she wrote a text, I hit him, right? And it was, and then they couldn't, that's the reason why Proctor went for her or whatever. Is that what you're saying, that text message?
Yeah, they try to like twist that around and say that.
So what was the I always wondered about that. What was the real text message? You got intel on that?
I don't have, I mean, I think Christy might have intel on that. I don't have the information on that.
Are they still running with that though? Are they still saying it's real?
Oh yeah. They're trying to still say that. I don't know. I left them all. Okay. So what's going on now is all of them hate Christy and I, because Christy and I called Kate out, and I called Kate out in front of everybody, and there's messages to back what I said. And I told Kate, I said, Kate, you seem to be trying to dictate to everybody what everyone's supposed to be saying or doing or talking to. And I'm going to tell you right now, you're not going to tell me nothing. And all of what you're saying is not making any sense to me. So I started questioning her. She did not like it. She started telling everybody I was crazy. I'm a psychopath. I'm all these things because I questioned her. I said what she was saying was not making any sense. I asked her for proof. I asked her for evidence. She couldn't back everything. So then she decided to try to get everyone else, whatever Kate says, everyone else followed suit.
Okay, so you heard that explanation about Karen Reed and the text message that she supposedly wrote in her phone search for a DUI lawyer, in her text message to David Yannetti. Comfort and Joy asks, is Innocence Fraud Watch only on Twitter? No, she's not. She is on Rumble, and she keeps her own blog. The link is in the description of this episode. So there's a fantastic timeline on there. And just really detail-oriented pieces on Karen Reed. So just wanted to show you this one. So this is her blog, Innocence Fraud Phenomenon, Killer Karen Reed retrial, Why Didn't Liar and Flying Monkey, Mary Bagwell, factor in murderers, meaning Karen Reed's DUI attorney Jack Diamond. So this is not talked about very often, the Jack Diamond DUI attorney and the contact that Karen Reed made with him. For over 20 years, Boston residents have been able to rely on the experience and aggressive attitude of Jack Diamond. Did I call him David Diamond? I called him Jack Diamond, I hope. Jack Diamond law offices when facing DUI charges. Our firm focuses on OUI, under the influence, or DUI cases in and around Boston. We have helped many of our clients to avoid a criminal sentence or have their license revoked by helping them use the right resource to make the most beneficial solutions for their situation. Why did Mary Bagwell presume DUI attorney was David Yannetti? The woman in the video clip below is called Mary Bagwell. Mary committed perjury on January 7, 2025. Read Mary Bagwell committed perjury during January 7, 2025 restraining order hearing for Aiden Turtleboy Kearney. Here, part 2 and part 3. Here's the timeline. On January 29, 2022, Karen Reed carried out a Google search for DUI attorneys at around 1:27 p.m. You can listen to Laura McLaughlin here. Should we listen to that? We're gonna
Why
have to
pay
skip
more
through
at your
the
local
ads.
pharmacy
Hold
when
on,
you can
guys.
save up to
Sorry.
80% off,
It's the
even
annoying
without
thing about.
insurance?
Take
And
a
one
look
more,
at this
of course.
strange device that I'm holding in my hand. It's smaller than a quarter.
My-
But
All right, so Ms. Giannetti, did that give you enough time?
Oh, I had enough time. Yes.
Okay. All right, so Ms. McLaughlin, why don't I hear you just briefly? If you could frame this, or Mr. Lally, whoever wants to.
Yeah, sure. The Commonwealth is moving to introduce a Google search the defendant conducted at 1:27 p.m. on January 29th, 2022. The Commonwealth would argue that the probative value of this Google search outweighs any prejudice to the defendant. The search in question is at 1:27 p.m. before the defendant had spoken to law enforcement. She conducted a search for DUI attorneys. The Commonwealth thinks that this is appropriate for the jury to hear as it rebuts the Bowden defense the defendant has laid out. Not that she did not intend to commit John O'Keefe. The defense has been that the defendant is essentially what's been represented in opening court was framed that she had no intent or opportunity to commit these crimes. Further, that she was not intoxicated at the time. So the Commonwealth feels that the probative value significantly outweighs the prejudicial value. It goes to her state of mind at the time that the search was conducted. Further, it also rebuts that there was any impropriety in the police investigation, or that, as the defendant has put it, that the police did not search any or investigate any other potential culprits. It also would go to the defendant's consciousness of guilt at that time. This statement is before she voluntarily gave an interview with law enforcement. It goes to her state of mind prior to that interview. And so for all those reasons, the Commonwealth would suggest that that Google search is appropriate, and it's not a typical case where it's an invocation of counsel, where law enforcement had not engaged her, and it goes to her state of mind at that time prior to any police involvement, and further to rebut that there was any improprieties in the police investigation, or that they should have investigated anyone else.
All right, and I appreciate, Mr. Lally, you bringing this to our attention to give us time to look at it. Ms. McLaughlin, I appreciate that you provided a very strong limiting instruction proposal. I'll hear you, Ms. Giannetti.
Thank you. Your Honor, you had asked that I use proof of the phone call from Michael Proctor to my client.
Oh, I didn't say proof. No, I asked if that was coming into evidence.
Okay, well, I'd like this marked for identification for the purpose of this document, if I can.
Sure.
Show counsel. It's been redacted.
Okay. So let's have it marked for ID before I hear you any further. So Madam Court Reporter needs to mark it. All right, and if I may have that. Thank you very much. Just give me a minute, Ms. Giannetti. All occurred, right?
That a call was made from Michael Proctor's personal cell phone number, you can see the last 4 digits there, to my client at 1:19 p.m. on January 29th.
Okay.
Approximately 8 minutes before she calls to investigate potential DUI attorney.
Okay, so focus on the law for me and tell me why I should exclude this.
Of course, yes. With regard to the cases that the Commonwealth has cited, I think the court has seen, one of them is an unpublished opinion, the other is a homicide case. They couldn't be more distinguishable from this case. With regard to the unpublished opinion, that appears to have been a gun charge where the defendant in that case did a search for a 9mm handgun on his cell phone. He did not ask for Google or a search in Google for a handgun attorney. He made a specific inculpatory search that the court ruled was relevant, and it was not outweighed by the danger of unfair prejudice. In this case, but we have a person being contacted by the police and then doing what a citizen has every right to do, which is to look for an attorney for representation. There's zero probative value to that. other than she's presumed to be innocent and she's seeking an attorney to defend that presumption of innocence. That's it. There's zero probative value. But there's an extreme and unfair prejudice in this case. Your Honor, the limited instruction that the Commonwealth has provided asks this court to instruct the jury whether her action in doing an internet search for an attorney indicates feelings of guilt by a defendant. I can't even believe that argument.
So let's just focus on the law.
I'm trying to, Your Honor. I'm
All right.
flabbergasted.
So what I'm going to do then is I'm going to stop you. So on the balancing act that I have to do, I find that the probative value is outweighed by the prejudicial effect. All right. So I'm not going.
All right. I'm not even going to hear your whole argument. You're outraged. Okay. That's enough. That's enough. Outraged. It's out. It's out. Confessed to attorney she clipped John O'Keefe. Oh, wait. I'm not sharing anymore. Hold on one second. Let me share my screen. Hold on one second. Karen Reed carried out a Google search for DUI attorneys at around 1:27 p.m. Listen to Laura McLaughlin here. Confessed to attorneys she clipped John O'Keefe. At some point on January 29th, Karen Reed also communicated with a lawyer named Jack Diamond. Was it during Karen Reed's text messages with Jack Diamond that she confessed to clipping John O'Keefe with her SUV? State Trooper Proctor and Buchanan seized Karen Reed's iPhone before leaving Denton to drive back to Canton. Below are the extracts from Commonwealth proposed procedure regarding communication stored on cell phone for examination of iPhone pursuant to a search warrant issued on February 2nd, 2022. Here, the troopers then seized the phone, an iPhone, color rose gold with a large crack on the back. Wonder what that's from. Did Karen Reed throw her iPhone? And on the lock screen, a picture of a pond and skyline. The trooper had been provided with the defendant's cellular phone number from other witnesses and confirmed the same number as the one listed for the defendant as a subscriber through Verizon on the ZTEX database. The defendant's phone was then transported to the Norfolk District Attorney's Office in Canton, Mass. On February 2nd, 2022, the Massachusetts State Police applied for and received a search warrant to examine the contents of the defendant's iPhone. On February 2nd, David Yannetti stated during Karen Reed's arraignment hearing, she hired an attorney almost right away, and by the way, there will be substantial issues regarding a motion to suppress statements here. August 22, this is the date state police were finally able to break the code to gain access to Karen Reed's iPhone. On August 17, 2022, Trooper Michael Proctor began to go through Karen Reed's iPhone extraction, but it was not able to finish a thorough search of the phone because he came across privileged messages between Karen Reed and her attorney. So just FYI, Michael Proctor has his hearing tomorrow. And we'll find out whether he loses his job or what kind of discipline they're going to put him under. March, he's already been on leave without pay as they investigated. Below are extracts from Commonwealth proposed procedure regarding communication stored on cell phone. On or about March 22nd, 2023, the Commonwealth provided the defendant access to her cell phone and all extraction data, all of it, With the one-sided knowledge of what her cell phone evidence may reveal, the defendant has continuously and purposefully hindered and delayed the Commonwealth's right to examine this relevant evidence on March 23rd. So she's delaying it and saying she knows what's on it. And she says, so she just says, like, keep delaying it, keep delaying it. On March 23rd, both the Commonwealth and the defendant approved to use the Digital Evidence Laboratory at the Massachusetts Office of the Attorney General to conduct the cell phone analysis. And isn't she friendly with the Attorney General? Below, no, not the Attorney General. That's the feds. Below is an extract from the Commonwealth's motion to compel defendant to comply with the agreed upon privilege filtration procedure relative to the defendant cell phone to provide the Commonwealth with the redacted extraction report here. On May 3rd, 2023, the court, by agreement of the defendant, ordered the cell phone examination to commence pursuant to the terms set forth in the filtered privilege protocols. Below are further excerpts from the Commonwealth proposed procedure. Trooper Nicholas Guarino, a certified forensic examiner, then attached the device to the decryption machine software to access said data from within the cellular phone. The decryption machine software eventually allowed access to the data within the device, and Trooper Carino completed an extraction report containing the data. Upon an initial cursory review, it was found to contain some type of communication between defendant and her attorney, David Yannetti. All actions relative to review of Trooper Carino's extraction report ceased. The communication between defendant and her attorney appears to have been Jack Diamond and not David Yannetti. Below are yet, so it goes on. So July 2023, Karen Reed asserted her attorney-client privilege related to 2 text messages from January 29th, 2022. And on July 18th, Elizabeth Little emailed prosecutor Adam Lally on Karen Reed's lawyer, Jack Diamond. I received the FedEx of Ms. Reed's phone and privilege log from Mr. Yannetti office phone on Thursday. Upon receiving the USB contents and images of the phone, there were several passwords needed to access the device. Okay, I've identified 2 text messages which were exchanged between our client and another attorney, Jack Diamond, not Mr. Yannetti. So that seems to support Innocence Fraud Watch's assertion here. Trooper Proctor never named lawyer related to client attorney privilege. Reed told me about a rumor that there were texts between her and her lawyer in which she implicates herself, texts that the police supposedly read when they confiscated her phone, but they will never be released because they're privileged. Proctor, the state trooper, himself referenced an exchange on the stand saying that he stopped looking through her phone when he saw messages between Reed and an attorney. But Reed and Yannetti each point out that they didn't communicate until after Massachusetts State Police had seized her phone and car. I didn't even have a cell number for David until around several hours after Proctor left with my phone. Reed says, I never texted him on January 29th. Proctor testifying on the witness stand that he saw text between David and me is a provable lie. State Trooper Michael Proctor never named any lawyer related to client-attorney privilege during his testimony, as falsely claimed by liar Karen Reed. Trooper Proctor's testimony was, after obtaining a search warrant for Ms. Reed, actually, let's just listen to it instead of hearing me read some more. Here's Michael Proctor talking about this text message exchange.
If you think what's happening in California is
Sit
bad,
through these ads
be
again.
prepared for major disasters.
Oh, Rumble, what are you doing to me?
The U.S. government doesn't
One
want
more
you to
time.
have this
The
extreme
U.S.
baseball
government
bat
doesn't want you to
flashlight.
have this.
There's a
What?
revolutionary gamma.
8/17/2022, 9:44 p.m.
Yes,
You see there's like sort of 3
Yeah.
responses from you.
I have you now.
If you could just read the 3 responses from yourself, sir.
Okay, so these came from me. Funny, I'm going through his retarded client's phone. No nude so far. I hate that man. I truly hate him.
Now, with reference to the investigation at this point, when you're talking about his client's phone, who are you referring to?
Miss Reed.
And with regards to the phone at that point, can you describe for the jury sort of what's going on during this time period of August 17, 2022 in regard to Miss Reed's phone?
So after obtaining a search warrant for Miss Reed's phone, we weren't able to extract any data from it until August of 2023. Troopers in my office knew I was going through the phone that evening. I was most interested in location data, text messages, Google searches. That was the update I gave the troopers in the office. It was a distasteful joke. I should have gave a proper update instead of that. I wasn't able to go through the phone as thoroughly as possible because I came across some a text between an attorney and Miss Reed, so I had to stop going through her phone, and I made my supervisor aware of those communications.
So there you go. That is, I thought, a pretty interesting part of history. Tammie asks, thanks for the super chat. Roberta, is Proctor going to be live? Excuse me. Thanks. I don't think it will be live. I think those police hearings are confidential, I would assume, but I would assume that there may be press and attend to figure out what's going on maybe afterwards. I don't think press can attend those. I think that they'll find out though afterwards. So we'll know maybe tomorrow, maybe the next day, I would think, if I had to guess. So I was going to talk about Richard Green, but I think I have to cut it short for today. I have been traveling, so I'm on the road right now, but I won't be live tomorrow. I won't be live tomorrow. But I may have a live episode, meaning like a premiere episode going at 6. So look out for that. So have a great night, everybody. I'll see you live Thursday and maybe have an episode up for you as a premiere tomorrow. Check my channel for that at 6. Have a great night, everybody. See you Thursday.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system stole my clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud.